Good morning, all. This case management conference is in the matter of CFI 053-2022 before His Excellency Justice Nasser al-Nasser. The claimant is represented by Al-Suwaidi and Company. Lead counsel is Mr. Mohammed Al-Suwaidi. The defendant is represented by Consulis Law. Lead counsel is Mr. Raza Mithani. Thank you, Your Excellency.
Thank you, Lina. So we shall proceed. Good morning.
Good morning, Your Excellency.
Good morning.
Good morning, Your Honor.
Both parties can hear me fine, yeah?
Yes.
Yes.
You can start, Mr. Mohammed.
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum. You see, we have a very simple case, but the respondent's attorney is trying to make it so complicated. We have a loan, they have, and my client is the beneficiary of that loan. They try to recover this loan. They paid some of it, but they did not pay it all. So it's a very, very simple case that we have. And from suggested time that Mr. Mithani wants to drag this case for a very long time. It's been already a drag for long enough, and they had an application to really strike this out, and took a very long time. And then in the end, we managed to His Excellency, Shams really gave a very good order to continue the proceeding. And that was in a nutshell what the case is.
So we're here today to set a timetable.
Yes, and I want to make it really as short as possible, because there is all the documentation that shows the agreement, the amendment to the settlement agreement, and the amendment to the settlement agreement. It shows all of that. And we already agreed on some of the payment that they made. But we're very, very simple case, I think. So I want to make it as short as possible.
Okay. Mr. Mithani?
Thank you, Your Honor. If I can just first of all address the point that Mr. Suwaidi made, that we're trying to make this case more complicated than it is. Actually, that's completely incorrect. You will have seen from the pleadings that there are a number of really very significant arguments in this case. Our position, of course, was that the claim itself had no real prospect of success. The claim was so misconceived, and so misconceived on so many different grounds, that the claim should be struck out. We made an application at a very early stage in the proceedings. The evidence in support of the application was filed by us on time. Unfortunately, the delay that took place was a delay in the court issuing its judgment on our application. However, our application was in part successful, and the court also ordered, no doubt a reflection as to what the court thought of the claimant's case, that they pay security for costs. Now, having said all of that, that's not what today's about. And I merely address that point because I feel obliged to do so. However, we are here, as Your Honour will appreciate, to set directions for this matter to go to trial. And in fact, the matter had laid in abeyance, and it was the defendant that suggested that this matter be listed for a case management conference, because as defendant, we don't want this matter hanging over our heads. That's to say, our client doesn't want this matter hanging over his head in circumstances where the claim itself is misconceived. Now, the position that we're in today is that, in fact, happily, we submitted a draft order to the court as to what directions ought to be made to progress this matter as expeditiously as possible to trial. And the claimant has actually agreed to the proposed directions. And so really it ought to just be a matter of issuing those draft directions. I hope that Your Honours had a copy of the draft order.
Let me check, please. Yeah.
Yeah. So the draft order is actually an agreed draft order. The claimant's counsel, you will have seen from the hearing bundle, submitted a skeleton argument in which they've indicated that the draft directions are agreed, and so therefore it ought to really just be a matter of issuing those directions.
I have only one comment on the draft order.
Yes.
Which is in relation to the expert report.
Yes.
I think we should not set the date, but set that if the party wishes to rely on an expert, should file an application to do that.
Yes.
Yeah.
Well, Your Honour, I have no particular objection to that. An alternative way of doing it might be to simply say that if we go to paragraph 6 of the draft order, we say experts' reports shall be filed in experts' reports, open brackets, if any, close brackets, shall be filed and served by no later than 4 p.m. 30th of January. And that way that saves the parties the need to make an application. But I'm entirely in Your Honour's hands.
There should be an application to rely on expert.
Yeah.
But so far from what I read, I don't think an expert is required. Yeah. But I have read the pleadings, and I have read the order that was issued by Deputy Chief Justice Ali Al-Madhani, and I don't think an expert is required. But if the parties wish to rely on an expert at a later stage, an application should be filed to do so.
Yeah, so I'm content with that word. I'm content with that wording, Your Honour. We can make an application if required. I mean, it's probably helpful to know that the order, what we've done with the draft order, and of course the claimant has agreed to the draft order, it simply sets out the stages in the proceedings that were the stages in the proceedings before our application to strike out was made. And so the different stages really reflect the different stages that were in the timetable in the original case management order that Your Honour made going back some time now before our original application. But as I say, I'm content with an order that says that if expert evidence is required, the parties may make an application to that effect.
And one more comment: does it require 3 days?
Well, that's that's a good question. Again, I think the way in which I would answer that question is that Your Honour's case management order that was made at the beginning of this matter provided for 3 days for trial.
Let's forget that order, and
yes.
From what I see, I don't think it requires 3 days unless you have lots of witnesses to present.
Yes. May I make this suggestion that we reduce the we reduce the trial to say 2 days, and we say that's a provisional time estimate. I have to confess, I'm always slightly cautious when it comes to trial estimates, because I've never had a judge be unhappy that a case is finished early, but I have had judges unhappy that a case hasn't finished on time. So, but again, I'm in your honour's hands.
The matter is the matter can be simplified. I think I don't think it's a complicated matter for it to run for 3 days. I think it's 1 max 2 days.
Yes. So yeah. So I think if we're exercising an abundance of caution, and it may be that we confer at a later date as to how many witnesses we have, as between the parties. But if we're exercising an abundance of caution, perhaps we put in a provisional time estimate of 2 days, and then if the parties think it's going to run short, then we can of course notify the court. Yes, at the pre-trial review. Yes.
Sorry, I did not get that now. Sorry.
We were discussing the dates, the hearing days.
Yeah, no. I just did not catch what the last things you said.
I said we'll decide. We'll put it as 2 days, and then at the pre-trial review, if more days were required, then we will adjust at that time.
Yeah.
But so far, or if it was less as well, we will adjust it at that time.
Yes. I mean, I think both Mr. Suwaidi, and I don't want to put words into his mouth, but I think that both Mr. Suwaidi and I would want to ensure that if less time than 2 days is required, then of course we'll jointly notify the court, because we want to make sure that the court's time is used efficiently as well. But at the same time, as counsel, we don't want to be criticised for saying a case is going to take less time than it actually does. But there'll probably be a little bit more. Well, there'll certainly be more visibility on that as at the pre-trial review. So I think your Honour's suggestion is very sensible.
Yeah. Anything else from the parties?
No.
You see, I think we also need to be mindful, because this is about the application of UAE law into this matter, and if we will apply UAE law, we'll also apply the evidence law of the UAE, and everything is related to all documented evidence that we have. And I don't know how we will bring it. They will bring witnesses that will contravene any written documents that we used as an evidence. So because I don't contemplate what kind of witnesses they will have. I mean, to be frank, this case was handled by another colleague of mine before, and then I took over things. And there's things that are, I have to swallow and just carry on with it. But so this is why I'm just saying where would the witness would be, and what issue that you're gonna use it as for the witness for.
This is between the parties on how the witnesses will present their witness statements and whether there will be a cross-examination. But as it is under the UAE law, when an application for an expert is filed, I think an expert on UAE law might be required. But this is, as I suggested as well, to be filed by way of application, that an expert on UAE law is required for the trial.
Yes, that's actually a very interesting point that Your Honour makes as to whether an expert on UAE law would be required. Certainly, I've seen cases.
I'm suggesting maybe.
Yeah.
Maybe. Yeah. So it's then when an application is filed, then the court might decide if it was required or not.
Yes. Perhaps we can, and just following on from Your Honour's suggestion, perhaps we can just put an additional direction in relation to expert witnesses, that the parties by a certain date, and I'm flexible as to what that date is, but perhaps the parties by a certain date can coordinate and, as between themselves, try and agree whether expert evidence is required. And if so, in relation to what?
In any ways, there should be an application.
There should be continuing cooperation, of course.
Yeah, but there should be an application as well to rely on an expert.
Yeah.
Your Honor, we are talking only about maybe 3 articles and 3 different laws, and it's plain and simple. You know, I don't think an expert really required. But
that's what I'm saying. An application is required if a party wishes to rely on an expert. If an expert on UAE law as well was required, the application will suggest why is he required? Why is the expert required? And if there are 3 articles which are clear, I don't think an expert would be required to define those 3 articles.
Yeah. The problem with these things, of course, is everything is clear until it's argued. But the provisions are clear to both sides, but they have a different interpretation as to what they mean.
That's why you're on the court, so the judge then decides the interpretation.
And, you know, being an Arabic-speaking judge, he also could read the original text, without
This
even knowing, without us knowing that you have read it anyhow.
This depends on who's the judge who will be at trial.
For sure.
Might be an Arabic UAE national judge or an international judge. So it depends.
Yeah. Okay.
Yeah.
I suppose the listing depends on the availability of the judges at the time. Yeah.
Exactly.
Yeah. Cool.
Okay.
Anything else from the parties?
No, that's all. Thank you very much.
Thank you, Mr. Al-Swedi. Thank you, Mr. Ramitani.
Thank you, Your Honor. Thank you
you.
very much.
Thank you.
Thank you.
I'll expect a draft order with the suggested amendments, yeah?
Okay. We work it together, inshallah, send it to you.
Thank you. Thank you both.
Thank you.
Thank you.